Hi, I'm attorney Gregory Dell, and I'm here with attorney Cesar Gavidia. And Cesar, today I want to discuss with you a case that you've been litigating against the Aetna Insurance Company. And if you can give us some background about what's been going on. I know it deals with an organic brain disorder stemming from a stroke, but what led to the denial of this claim, which is obviously why you're in litigation?
Yeah, well, initially, and I know a lot of potential clients and others that have contacted us, this isn't unfamiliar to them. Initially, they had actually approved his disability claim. He'd had a stroke back in 2011, and 3 years later, he'd actually started working again. He went back to work, and about 3 years later, he started having symptoms, and probably had symptoms all along, but he wanted to get back to work. He was motivated to try to get back to work and get his life back after his stroke. And he started developing and having, especially when he was hard at work in his job as a software developer, and these memory impairments and cognitive difficulties and visual and audio, spatial and perceptual issues. And in working in his specific occupation, being very analytical, researching things and reviewing data and developing software and doing different things that he was doing for his employer, he really wasn't meeting that mark and those expectations that his employer had for him. And so he ended up going on disability. His doctors had actually put him through a neuropsychological exam, which, as you know, it basically assesses the person's cognitive abilities and functioning. And Aetna's own medical people in-house even determined he had these impairments and he had these problems, and they approved him. And they paid him for almost 2 years, okay? And as soon as almost the 2 years was up, probably about 4 to 6 months before the 2 years was up, the own occupation period was up, they decided to put him through another medical review. And that medical review said, oh, we've reviewed the medical records and we don't think he's disabled any longer. And in addition to that, I guess they had done some research into his social media activity, Facebook and those things. We always talk to our clients about that type of activity. And even though it could be completely benign and it could be completely irrelevant to what that person did in their occupation, it's giving the insurance company a very unique look into their life, into everything about them, all their thoughts that they're posting, all their opinions that they're having, and of course any pictures that they have of activities they're doing with their families. And based on that information, Aetna decided he wasn't eligible for benefits anymore.
Was there anything unique in the social media profiles that they found?
He had a lot of pictures with his family, doing different activities with his grandkids, with his own kids. He was going to different places. He'd actually moved within that period of time that he was on disability. He'd moved from one city to another city. And so, based on this level of activity, the insurance company thought, oh, he mustn't have any of these cognitive impairments he's claiming he has. So that's when he came to us.
And his job was what's considered sedentary?
It's considered sedentary. I mean, physically, what we're doing right now, this is sedentary. We're just sitting here. And we're talking, and it's not much different from what most people's jobs are that work in an office. They're sitting most of the time, but if your job just required you to sit and not do anything else, then everyone could perform your job. But not everyone can perform a job that requires, complex analysis, complex thinking, and really requires a lot of very specialized abilities in order to perform them. And yeah, they considered his job sedentary, but intellectually, it was very high in terms of demand there.
His policy, you said they cut him off after paying for about 18 to 20 months.
Right.
Was there a change of definition, and if so,
So
what?
that's part of what's in dispute in litigation. So what I've discovered here is that in the policy, it looks to be own occupation through the entire period, meaning that in order to qualify for benefits, he has to be disabled from his own occupation. But in the denial letters that I've seen, they're talking about this change of definition after 24 months to the any gainful occupation, almost very similar to that standard set out by Social Security disability. And so that's something that I'm legally disputing with them, because it appears that the summary plan description, the policy that they provide all their employees, is showing this policy to be strictly own occupation, which would be a big advantage to us in this case.
Is he approved for Social Security disability?
He has not been approved for Social Security disability, unfortunately.
Is that a pending appeal?
That's
or-
pending appeal. It's very common, in fact, for people to file for Social Security disability and get denied in the first go around, and they have to go through the process of hiring a specialized lawyer in Social Security disability benefits to pursue those for them. But yeah, he's in the process of doing that.
Do you think the dynamic of the case would be different had he initially been approved for Social Security disability?
It's difficult to say. Let's say that the Social Security Administration had put him through their own battery of tests. I mean, it's very hard to argue for Aetna that the battery of tests of Social Security disability was performed was inadequate, or it was biased, or it couldn't be relied upon. So I think that perhaps if he'd been approved for Social Security disability and they'd done some of those cognitive tests, it would have been very difficult for them to then argue that he, was no longer disabled under their terms. But after they denied him, in our administrative appeal, we sent him to our own neuropsychological examiner. And when we did that, it turned out that what they've discovered in the new neuropsychological exam, this is 2 years after he had his first one, that his impairments stayed the same. They hadn't improved at all. And that's something that the neurologist expert that Aetna hired was actually disputing and saying, oh, you can't rely on that exam. Didn't even say why you couldn't rely on it. That guy just did like a 30-minute physical exam of him, and did what's this other cognitive screening type of test, which is actually done before you send someone to more comprehensive cognitive testing, and said that he could perform his own occupation.
Did Aetna request the raw data from the neuropsych exam?
They did not. They didn't request the raw data. They didn't send them to their own neuropsychological examiner. They didn't really do anything. They had it reviewed by one peer-reviewed neuropsychologist that basically wanted to look at the neuropsych that we did and just try to rip it apart and find any possible flaw or hole in it that they could find from a person that's completely unbiased. They don't do this for a living. They're not some court, hired expert or specialist that gets hired all the time to perform these tests. This is, a neuropsychologist that your doctor would refer you to, or anybody else would refer you to, that has their own practice that, sees patients every day.
So he had a neuropsychological exam during the appeal stage, which
Right.
was 2 years after he initially became disabled. When he first became disabled and Aetna approved him, they actually had him physically examined?
They didn't have him physically examined, but his doctor had sent him to a neuropsychological referral.
Okay.
And it was based off of that neuropsychological referral that his doctor had sent him to that they initially approved the benefits.
So Aetna never physically examined him?
They physically examined him after we'd already filed our appeal. They wanted what's called an independent medical exam.
Oh, so they did do that?
They did do that by this neurologist that only looked
Okay.
at him for like 30 minutes. And then when they did this cognitive screening test, which isn't an appropriate test to even, show cognitive deficiencies. It's basically what's done just as an entry-level quick exam to determine if that person justifies further examination.
Okay, now
So-
it's important for people who are in this situation to realize that ERISA requires the disability company, when doing an appeal, to use the appropriate medical specialist to review
Right.
a claim. It appears in this claim that, considering he's claiming neuropsychological difficulties, cognitive difficulties, that Aetna should have used a neuropsychologist, which is a completely different subspecialty than neurology.
Right.
And in the neurologist didn't even look at the raw data. So I don't know how the neurologist could even be qualified to evaluate his cognitive position without even looking at the raw data or having the training that a neuropsychologist has.
I agree completely, yeah.
So it seems like, unfortunately, a typical sham Aetna denial, where somebody chose the wrong particular doctor, and this doctor tried to bend over backwards to help Aetna to do what he or she could do to get the claim, continue to be denied. So at this stage of litigation, just talk for a minute, what are the potential outcomes?
Well, realistically, in these ERISA cases, we're up against a very difficult standard of review most times. We do what we can with the cards that we're dealt in terms of the law. ERISA is very restrictive in the sense that if the insurance company puts in a discretionary clause in their policy, we have to prove that the insurance company acted arbitrarily and capriciously, and that's probably the standard that we're up against here.
Okay.
So we're going to have, if this case ends up going to trial, we're going to end up having a federal bench trial or a motion practice in front of the judge, and be submitting cross motions for summary judgment. And basically, the judge is going to look at the arguments put forth by the attorneys, the administrative records and the exhibits that the attorneys are citing to, and they're going to decide, one, did Aetna first act wrongfully in terms of finding that the person was not disabled, and two, did they act arbitrarily and capriciously? So if, you'll notice I gave two things they have to do. So if Aetna first says the person's disabled, but we think that Aetna acted appropriately by referring them to this neurologist and having the case reviewed by this other, neuropsychologist, then we lose. Then basically a disabled person is walking away without their disability benefits, even though the court's acknowledged that they're disabled. So we do have opportunities to get into settlement discussions with them, which we always actively seek, but there's no guarantee the case will be settled. It's up to the parties whether even reasonable settlement discussions can be had when you have cases that are so strong in favor of one side or the other.
Right. So what you're hoping for is either potentially what would be a lump sum settlement of some kind, which would take away the risk of going to trial. And if you do go to trial, the potential outcome would be that the court either one awards benefits and says I'm going to pay the back benefits, and then we could file a motion for attorney's fees, which are not guaranteed, but hopefully would be approved. The court could say, I think they acted arbitrary and capricious, but I'm not going to award benefits. I'm going to remand the claim back and give Aetna another shot, which is kind of a quasi-win because then Aetna gets another bite at the apple.
And they're pretty clever because remember, they denied his claim before any, we're arguing that it's own occupation, but before that transition to ENIAC would occur. So basically what they've done is they limited the liability of this disability claim. They've limited what the judge could even look at in terms of whether this person is disabled. They're just looking at whether they're disabled from their own occupation for these specific months. And then the court, even if we win, has to remand it back to Aetna to determine if they're disabled from any occupation.
Well, arguably, because if he had a sedentary occupation, you can argue that the any occupation is sedentary as well. And then the last outcome would be the court says, no, I agree with Aetna. Claimant loses, no benefits awarded, and possibly subject to paying attorney's fees to Aetna, which is another big risk. So, we'll obviously stay on top of this one, and I hope that we get the best outcome possible for this particular claimant. But it's a good case to discuss to show what we do day in, day out on these particular claims to help get benefits approved. So if you have a claim with Aetna or any other long-term disability insurance carrier, feel free to give any of our attorneys a phone call. We always offer a free consultation, and we're available to help you anywhere in the country.